let's get started. It's been a while, so we're going to do committee introductions. I'm kidding. It's been a whole week. I don't think we've ever taken off a whole week. Not even probably days combined. Have we not taken off that many days? We do have minutes to approve from February 16th and 17th. Those were sent out in the past. It's been a while you've had them. Is there any corrections or changes? Not. Is there a motion to approve? Representative Hoheisel.
Thank you, Mr. Chair. I move that we approve the minutes.
A second by Representative Hobson. Any discussion? All in favor? All in favor say aye. Aye. All opposed say no. Minutes are approved. We have two bill hearings committee. I'll open the first one, which is Senate Bill 419, and we'll ask Natalie to give us an overview.
Thank you, Mr. Chairman. Senate Bill 419 would allow certain employees of the Department of Corrections to attend the Kansas Law Enforcement Training Center. New Section 1 would allow the Secretary of Corrections, with the consent of the Director of the Police Training at the Law Enforcement Training Center, to designate an employee other than a special agent to attend the Law Enforcement Training Center or any training school certified pursuant to KSA 745604A, or to attend courses provided by that training center or training school. The employee and the department would be required to receive a transcript of the courses that are successfully completed by the employee. And then Section 2 amends KSA 745602 to include special agents of the Department of Corrections in the definition of a police officer or law enforcement officer for the purposes of the Kansas Law Enforcement Training Act. And I can take any questions.
We have questions for Natalie. Representative Carmichael.
Thank you, Mr. Chair. Ms. Scott, as I recall, a year or two ago, we passed a law, I think, that allowed the special agents from Department of Corrections to go to KLETC, be certified law enforcement officers. Am I remembering that generally correctly?
Yes, Mr. Chairman, Representative Carmichael, and that's why you'll see that this is allowing an employee that's other than a special agent, because we did make that change. So this would allow other employees.
And so then, to turn to a matter of statutory construction, this says designate an employee. Now, "an" to me suggests singular. Is that the intent, that it is one employee, or is it any employee can be designated?
Mr. Chairman, Representative Carmichael, you'd have to ask the proponents about what the intent would be. Mm-hmm. But to me, that's a singular employee at a time. I don't know, how often they would be able to send a different employee, but.
And by the way, I apologize for asking you about the intent of the bill. That was poor phraseology on my part. But if it's "an," it doesn't say one employee a year. It doesn't say an employee at a time. If I were to read this, I would say they get one shot to train up one person. But then when I look at the fiscal note, it assumes there's going to be two employees a year going to KLETC. In your review of the bill, do you see any language that would suggest that two employees a year go to KLETC?
Mr. Chairman, Representative Carmichael, our statute on statutory construction does include a provision that the singular includes the plural. So I suppose, but I agree with you that an argument could be made. I could see where they may make that argument, that it's intended to only apply to one employee.
Okay, well, we'll visit with the proponents about that. Thank you for your help.
Any other questions for Natalie? Okay, thank you, Natalie. For proponents, we begin with Randy Bowman.
Good afternoon, Mr. Chairman, members of the committee. My name is Randy Bowman. I'm the Executive Director of Public Affairs for the Kansas Department of Corrections. It's a privilege to be before you today and share a few thoughts from us on this bill, and maybe address a little bit of that line of questioning there if I can work it into the presentation here. Again, but thank you. Yes, the Kansas Department of Corrections is a proponent for your passage of Senate Bill 419, and we did ask for this bill to be introduced. To kind of reflect back on the history that I think might have been part of where Representative Carmichael was thinking. This chamber did work this same topic, the exact same bill language as is before you today, 2 sessions ago. You passed it out at the whole House, 125 to nothing. Then, for all of us, as we tragically may recall, COVID hit. So you had an abrupt end to your session, and the Senate was unable to then follow through and do that on that side. So our premise in bringing this bill this year was simply to do what we tried to do in 2020 and get it done in 2022. Same language, hopefully same level of simplicity. And the Senate saw the wisdom of that, thank goodness, 40 to nothing on February 23rd. And now we just keep working the process on this side. So that was the intent for this session. Why did we need this bill then or now? For reasons that are not really clear historically. While the Kansas Department of Corrections, certain employees, those special agents, are recognized as law enforcement officers and other provisions of law, they've never been specifically written into this training law. And while it might be a stretch for all of our collective imaginations, if you might think of the Department of Corrections as a very large organization, which it is, when it comes to this piece of our workforce, currently 9 special agents, and maybe another person or persons, as might be identified need, getting this specific training, I'd encourage you to think of us more like a small rural police department or sheriff's department, where we don't really have the capacity to develop this very specific set of training that is very much needed, because our special agents, our law enforcement, if you will, are out there working with your local police and sheriff's departments day in, day out in the community to work on returning absconders to facilities, working on joint task forces, those things. And it's really important that when they're engaged in those activities, which have a high risk for something to happen to them or a member of the community who might be a stander by to some action, that they have the same training, they have the same skills, they're on the same page, if you will, as to this is how we're going to go about getting this person safely into custody, removed from the community, and put back wherever he's going to go. So we really need the training to be on the same page. Just historically, that had never been an opportunity for the department. That's why we brought it up in 2020. So I hope that kind of explains where we're coming from. This is the intent of this and the need for it. And yes, you have seen it before. If you would favorably pass this out of committee and on to the House here in the next couple of weeks, we would be sincerely appreciative. And with that, I can stand for questions at the appropriate time.
Very good. Representative Carmichael.
Thank you, Mr. Chair. Mr. Bowman, how many people are you planning to send to KLETC?
So we have 9 current special agents.
I understand, but how many are you planning to send to KLETC? All of them? Some of them? None of them?
It could be all of them is the best way I can answer that, because it will depend what their prior qualifications are when we can hire them. We have turnover periodically. So if we hire somebody who's not already certified, we would need to get them through this program.
In the fiscal note prepared by the Division of the Budget, they say that it was reported to them by the Kansas Law Enforcement Training Center that they estimate 2 additional individuals will require basic training each year as a result of the enactment of the bill. Do you know where KLETC came up with that number?
My best recollection is they're kind of looking at, we get everybody through that with turnover. That's probably what we might expect in a typical year, is this will live on in perpetuity.
So I take it it's your intention that this will authorize an unlimited number of Kansas Department of Correction employees to attend KLETC for the future, sometime in the future, unlimited number. It may be 9 a year, it might be 2 a year, it might be none, it could be more. Would that be fair?
I would not think that fair. I would think
then help me understand why that would not be a fair interpretation of your position.
Only if we turn over every single employee would that be fair, and that's just not been our experience. These positions are pretty sought after in the department. Once you get in, once you gain the skill set, hopefully you keep working on the compensation side and we're able to retain people. We're just unlikely to turn over that many, Mr. Carmichael.
It's representative, but
representative, sir.
Thank you. But finally, Mr. Chair, is there any reason we shouldn't just limit this opportunity to those who are special agents so as to make sure that rank and file prison employees aren't sent to KLETC just because, yeah, we got a shot and we can send some of these folks up there and get them trained? Why shouldn't we just limit this to special agents?
If I can contribute that, I think that would
Yes, I'm
be
asking you,
Chairman.
Mr. Bowman.
But I think the safeguard on that is that has to be approved by the director at KLETC. So whoever occupies that seat, if the secretary were to call up and said, like, put 3 people through, as I read that, then that person could say no, or all 3, or 1 or 2. So there's a safeguard.
Thank you. Mr. Chairman, I would hate to put director back in that position. Thank you.
Representative Humphreys.
Thank you, Mr. Chairman. Thanks for being here. Could you just explain to those of us who aren't familiar with the difference between a special agent and who that might be, and then some of these other employees that might be someone that would be designated to go?
Yeah, sure. Mr. Chairman, Representative Humphreys. So a special agent is one small unit in the department who works for Enforcement Apprehensions and Investigations Director, who are working in our parole offices, and they're going out finding people who have gone from parole, occasionally doing a high-risk home visit with our parole agents. So the rest of us doing corrections work in the facility, IT work, accounting work, public policy work, don't fit that definition. That's literally 9, as I answered that first question, position descriptions currently. Then the reason the ask is in that bill from that also then allows, say there's a person in a prison facility who's not a special agent, but they're collecting evidence when things happen in our facility. So maybe there's a training from KLETC or one of the law enforcement agencies they approve specifically to evidence collection. Well, we might like to ask the director of the KLETC if we could get that person through that training so we get that good quality evidence collection to pass off to the prosecutor who's going to prosecute that person for whatever crime may have been committed in the facility.
It would be kind of a specific case or person or class that you would be wanting them to take?
I think class is how I would answer that. Yeah, it's not any intent of the department to put our 2,000 corrections officers through this. That's not the focus of their work.
Okay. Thank you. Thank you, Mr. Chairman.
Yes.
Further questions? Thank you.
Thank you.
Cool. Thank you. Next, Ed Klump.
Thank you, Mr. Chairman, committee members. My name is Ed Klump. I'm here on behalf of the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. We support this bill. As the previous proponent talked about, we work side by side with these officers on a daily basis in sometimes very volatile situations or potentially volatile situations. We think adding this training is very important for those special agents of the DOC that so they've been talking about. This is not only good for them, it's good for us. It increases and enhances our coordination with them, our safety and operations with them. And it's also good for everybody that may be around these operations. The person that's being arrested, they're sought, the other people that may be in a residence or a place where we contact them, and even the general public around. This is all about safety, coordination of efforts, making sure we're all on the same page. We kind of understand what the rules are and how we've been trained, and we're well coordinated. So with that, Mr. Chairman, I'll stand for questions.
Questions, committee? Representative Schreiber.
Thank you, Mr. Chairman, and thank you, Mr. Klump. KLTC, how often do they hold these type of classes throughout a year?
KLTC kind of has 2 different paths. One is the recruit training, and those are done on an ongoing basis. They've really drastically changed how they do that, and it's proven to be very, very beneficial to the program. Where they used to be, they run one class, and it might run, several months. And now they have multiple classes going on. They start them every few weeks. And so there's multiple classes going on. There's smaller classes. They get more one-on-one training, do more hands-on training. And so those are going on constantly. And then they have the in-service training, the additional training that's done. Like they may hold a special class on human trafficking. They may do a special class on evidence collection. They may do a special class on electronic evidence collection. And those are posted, and any law enforcement officer in the state that's under the act can participate in those. And I think that's the purpose of this, is to bring them under the act so they can participate in those classes, as the training may be beneficial to them and in the mission they're trying to accomplish.
For these new people that might be coming in, they would receive that basic training first, and then
That may be more appropriate for Mr. Bowman, what their expectations are on that.
okay. Thank you, Mr. Chairman.
Any other questions? Okay, thank you, Ed. I have quite a list of written proponents. Is anyone else here planning to speak as a proponent? I see we have quite the crowd. Just wanted to make sure. Okay, I'll go through the list then. We have written proponent testimony from the Kansas Highway Patrol, the Kansas State Trooper Association, the Kansas Bureau of Investigation, the Johnson County Sheriff's Office, the Kansas Gang Investigators Association, the Pawnee County Sheriff's Office, the Commission on Peace Officer Standards and Training, the Kansas State Lodge Fraternal Order of Police, and the Kansas Internal Affairs Investigators Association. Any other proponents? Okay, I do not show any neutral or opponent testimony. Is there anyone? Not seeing any, I'll close the hearing on Senate Bill 419. Open the hearing on House Bill 2736 and have Natalie come back up to give us an overview.
Thank you, Mr. Chairman. House Bill 2736 would limit the liability of optometrists and ophthalmologists who report information to the Division of Vehicles relating to a person's vision. The bill amends KSA 8295. That's the statute that provides the vision standards for driver's license examiners to use in evaluating driver's license applicants. Current law there in subsection F provides that no optometrist or ophthalmologist reporting to the division or to a medical advisory board in good faith any information which that person may have relating to the visual condition or other ability of an applicant for a driver's license to safely operate a motor vehicle shall be subject to a civil action for damages as a result of reporting that information, including any information provided in a vision report. This bill would amend that liability subsection to provide that no optometrist or ophthalmologist reporting to the division or to the medical advisory board any information that such person has relating to the vision of an applicant for a driver's license shall be liable for damages to any person subsequent to the issuance or renewal of a driver's license to the applicant. And I can take any questions.
Any questions for Natalie? Representative Carmichael.
Thank you, Mr. Chair, and thank you, Ms. Scott. One of my responsibilities is to do something called a bill brief for my caucus. And as you may have seen this morning, I managed to screw it up, and I sent Representative Heiberger up there to make the mistake that was my fault. But can you help me, either you or research? I'm supposed to put down who it is that brought this bill to the Committee on Federal and State Affairs. I don't know if there's some way we could look and see who introduced it on behalf of whom, or it may be one of our proponents can answer that question for us, but it's something to make my life easier. Thank you.
Sure, Mr. Chairman, Representative Carmichael, I will get that information for you. Just for anyone listening, if you do go to the bill page of House Bill 2736, it should say on there who made that request. And if it's not up there yet, then
unfortunately, all it says is Committee on Federal and State Affairs. It doesn't say who introduced the bill in the committee or on behalf of what organization or person. That's why I inquired.
I will get that for you.
Any other questions for Natalie? Okay, thank you, Natalie. Committee, this is a bill that was, well, it wasn't a bill. This issue was brought to our attention late last week, I think. Quickly introduced in Fed and State yesterday, referred to us yesterday and set for hearing. Todd and others have been working on this, and so we'll have Todd come on up. Todd is our only in-person proponent. So explain away, Todd.
All right, thank you. My name is Todd Fletcher. I'm the Executive Director for the Kansas Optometric Association. We did bring this bill forward. We represent optometrists across the state of Kansas. And as you probably know, when you go get a driver's license, you apply for a license or get a renewal, you go into the driver's license office and you do a vision screening there, and you have to pass a 20/40 or better. Otherwise, you have to go to the optometrist or ophthalmologist to get an examination to determine if you have the necessary visual skills to operate a vehicle safely. That also applies, I believe, if they do the online renewal. It's every other time now for an option. So what what we're here to talk about is that vision form. We want to make sure that when the doctors are providing that information, they're providing that information based on the facts they have available. They're providing the facts about the patient's visual acuity, whether they're 20/40, 20/50, 20/60, or whatever. If they have the visual field, so their peripheral vision to see how wide their fields are. And if there's any other vision conditions that are going on, so whether they may have macular degeneration, that their vision is deteriorating, different things like that, that they provide information to the Department of Motor Vehicles. So then they in turn take that information into consideration, as well as other information. So a patient may have some other medical issues or mental health issues, or just be a really bad driver. They're looking at that all in one category, and then they make that decision. So the liability protection in here is important. There's been a situation where that kind of liability has been placed on the optometrist for providing the factual information. And that's had a chilling effect on doctors being willing to provide this service to their patients. This is something they do for their patients when they come into their office. And optometrists and ophthalmologists both do this to make sure that patients are able to drive. And we are concerned that if this isn't addressed and there's not protections in place, that optometrists and ophthalmologists aren't going to be willing to fill this out. In addition to that, that ultimately then kind of raises the bar for being able to get a driver's license, because if you don't have that vision form option, then you have to be 20/40 or better to drive. And we're worried that folks won't be able to, that might have been in that gray area before, that may have the necessary visual skills based on what their optometrist or ophthalmologist said, but not qualify for the vision screening at the DMV. So that's why we brought this bill forward. The issues has come to light in the very recent last few weeks, last few days actually. And so we wanted to bring that forward and try to get this addressed. We're already having a few folks that are not getting driver's license renewed because the optometrist is unwilling to fill out the form because of the liability concern. So we wanted to address this so that we can make sure that patients are still able to get those forms filled out when they request them.
Questions, committee? Representative Carmichael, then Humphreys. It's okay. Representative Humphreys.
Thank you, Mr. Chairman. Thank you, Mr. Ranking Member. So my question is, so right now the current law says no optometrist or ophthalmologist. I mean, you can read what it says that it said before. Hang on, I'll just repeat what Natalie said. Shall be subject to a civil action for damages as a result of reporting such information. So tell me how this is different than what is already in current law.
Okay, so one key thing that if you notice there references the phrase good faith, and that's what's being challenged right now in a court, is that they feel that because a doctor is filling this out for multiple people, that they're not doing it in good faith. We argue that that's not necessarily the facts of the case, but that's what the case is being charged. You know, that's what the issue is here. So this provides protection for that. And I think it's important too to realize that if a doctor is doing something that's negligent, where they're providing not factual information, they would still be liable for damages. It'd be under their medical malpractice. The particular case that's in reference is actually it's going after their personal liability, not their medical malpractice, because they're not claiming negligence. They're going after the doctor's personal liability because he provided information in a situation. So when we talked to the DMV, they felt like this is an issue that we could address in statute to help resolve some of those concerns. But again, it doesn't release the doctor from the liability if they are doing things incorrectly or and negligent.
And that case has not been resolved yet.
That is correct.
Okay, thank you.
Sure.
Thank you, Mr. Chairman.
Representative Carmichael.
Thank you. First, to try to answer the question I had for the revisor, did you introduce this in Fed and State on behalf of your association?
Yes.
Okay, I got my bill brief taken care of. Thank you. It's very important in my life to try to, okay. But let me turn to something more serious. The potential plaintiffs that you are trying to prevent from bringing a lawsuit, are they other people on the highway? Are they the doctor's patient who's the driver of the car? Who is it we're trying to stop from suing?
I think it's from anybody that was, those that were affected. So if a doctor is literally just providing the information, the facts of this, they're providing it to the Department of Motor Vehicle so that they make that decision. That it's not the doctors that are making the decision about whether the individual is safe to operate a vehicle. It's actually the DMV based on the facts that were provided. It's no different than a medical physician providing medical information or that kind of thing. So the idea is that it's making sure that the provider is not liable for the information if they're just presenting the facts.
Well, then let me try to phrase my question more precisely. If we have an applicant for a driver's license and that applicant goes to their optometrist or ophthalmologist and says, I need an exam and a certification to take to the DMV, and the doctor negligently fills out the form wrong and says they don't see well enough to drive, and it gets sent into the DMV and the driver's license is denied because that's what the report says, are we trying to stop the driver, the licensee who didn't get their license, from suing the optometrist or ophthalmologist?
That is not the intent of this. This is to provide remedy so that there's no liability for the doctor if they provide factual information as all. So and there would be nothing to prevent an applicant from going to another optometrist or another ophthalmologist to have a vision form filled out and get additional information, get a second opinion essentially, and going back to the DMV if they felt that they were so inclined to do that.
But with respect, my question is, who are we trying to stop from suing? Are we trying to stop the driver who, quote, fails the test from suing over the opinion or the, quote, facts from the optometrist? Is that one of the folks that we're trying to
I don't think that's the intent. I think that is one of the things that would be a factor here, but I don't know that that was the intent of the doctors who asked us to bring this legislation forward. But I think that would be a legitimate issue.
Well, it's then turned to a second category of people, and that's the person who is injured because somebody's out driving with macular degeneration and runs over somebody in a crosswalk. Are we trying to stop the victim who got ran over in the crosswalk from suing the doctor, the optometrist or ophthalmologist?
I think if the victim is suing, we're trying to keep them from suing the doctor for factual information that they provided. If the doctor provided negligent information, or they did not report that they had macular degeneration, or that would be something they would be liable for. But if they're providing factual information, then that's what our argument is, that they should not be sued for providing the facts to the state, which then makes the decision, because the doctor doesn't issue the license.
So are you trying to stop the person who got ran over by the person with macular degeneration from filing a lawsuit against the optometrist or the ophthalmologist?
That would be one of the situations, yes.
Okay. But then you differentiate between facts and apparently things that might be covered, that you say are negligence and covered by medical or professional malpractice policies, and you're not trying to stop those types of claims?
No, we're not actually. That would be responsible to file those if they were negligent. This is just for if they're providing factual information. We just don't believe they should be held liable for providing that factual information.
So if we were to add to this proposed statute words to the effect that other than resulting from professional negligence, so that those types of claims are preserved, would that be acceptable to your clients?
I would have to check that. I wouldn't have any personal concerns with that, but I would have to check and get back with you on that.
Okay. Well, I'll work with the revisor to try to draw some language, and if we can, I'll get it to you just as quick as we can reasonably process it. Thank you.
Okay.
Other questions for Todd? Todd, I noticed that the bill as drafted has the effective date being publication in the statute book. Are you concerned about waiting? Do you want that to be in the register? I mean, we're getting close to now. It's probably not going to matter much.
We're definitely hoping for as soon as possible. So if that would be an option, that would be great. Yeah.
Any other questions? Okay, thank you, Todd.
Thank you.
Committee, we have written proponent testimony from Larry Ann Brown on behalf of the Kansas Society of Eye Physicians and Surgeons. Any other proponents? Flip the page. I do not see any opponents or neutrals. Anyone here? Okay, we'll close the hearing on House Bill 2736. Now let's work some bills. You ready? Okay. First one is House Bill 2447. And I will have Natalie give you a very brief explanation of what the bill is, knowing that I'm going to gut it here in a second.
Thank you, Mr. Chairman. Spoilers. House Bill 2447 would terminate the transfer of any remaining unencumbered amount in the Securities Act fee fund over $50,000 to the state general fund.
So committee, that's one. There was a similar bill on the Senate side, which was moving forward. So we were advised that this did not need to. So it's sitting there and we can use it. So I have an amendment that we'll have Natalie send to Kathy and Kathy send out to you all. As I explained to you, I think last Tuesday, my hope is to take 2447 and to put in one of the pieces of House Bill 2538. That's the bill that we heard some time ago. We had representatives from the Shawnee County DA's office here. 2538 would have dealt with hearsay in preliminary hearings, some time limitations in there, but there was also a provision that would allow for the use of two-way audio-visual communication devices in prelims. And so it's that piece that I'm going to attempt to put into 2447. So you'll get that amendment in a second. I will, as you'll see, most of it's stricken out, and then on page 3 of the amendment, there is one line in there where it adds the defendant and the state shall be permitted to present the testimony of a witness through a two-way electronic audio-visual communication device. So I will move my amendment. Is there a second? Representative Samsel, any discussion? Representative Wheeler.
Just an observation and perhaps some input. I've also, I think, mentioned it to you, Chairman, as a person who has tried many, many cases in court. I have found, particularly at preliminary hearings, the best way to assess the viability of a witness is to watch their reaction while testifying, and that is not really available through audio-visual. I can appreciate the intent of this and the expense that it saves, but I also am concerned about the effect that it might have on persons cross-examining such a witness. Thank you.
Further discussion? Seeing none, I will move my amendment. All in favor say aye. Aye. All opposed say no. Motion carries. I would. So Kathy, would you record Representative Carmichael as a no on that amendment? Any other amendments on 2447? Now, is there a motion concerning 2447, Representative Hoheisel?
Mr. Chair, I move we pass out 2447 favorably as amended.
A second? Representative Neely, discussion? I guess it'd be the same discussion as we just had on the amendment. Ditto, Representative Wheeler. Seeing none, Representative Hoheisel, you may close.
Close.
Heard the motion. All in favor say aye. Aye. Opposed say no.
No.
Motion carries. The yeses that would like their votes recorded, Representative Hoheisel, Representative Heiberger. The no votes that would like to be, and Representative Neely as a yes. The no votes are Ohabisam, Carmichael, and that may be it. Representative Keithers just looking at the screen. Yes, and we'll make that a substitute bill.
I just don't, Mr. Chairman, I just don't need to have my vote recorded. It was a no.
You're good. Thank you. Next, let's look at House Bill 2495.
Thank you, Mr. Chairman. House Bill 2495 would prohibit the disclosure of personal information about a person's affiliation with an entity that is exempt from federal income taxation under Section 501C of the Federal Internal Revenue Code.
Any questions for Natalie? This is one we heard. I was going to pull it up quite some time ago. We had some neutral and maybe even opponent testimony. I encouraged the parties to get together to work on this, and they've spent the last probably month working on it. And so I have another amendment, or an amendment on this one that will get distributed. Okay, you should have it. Take a second and read through that. You have any questions for me or Natalie? Again, these are the amendments that were proposed to address the concerns raised. I haven't even made my motion yet, but I guess I could go ahead and do that. I'll make the motion. Is there a second? Representative Hoheisel. Discussion. Representative Humphries.
Do you mind just explaining a little bit of the gist of the amendment?
Yeah. Okay. So instead of, as you'll see, it's stricken several times where it refers to entities that are exempt from federal income taxation under section 501c3. And then if you look at almost the last balloon on page 2, it now defines, it deletes that phrase and inserts nonprofit organization, and then a new definition for what nonprofit organization means, making sure we include all the entities that were here and had concerns. And then the bulk of this is setting forth what provisions the section does not apply to. And so now you'll see we've added 6 to 11 new groups of entities or types of information that this does not apply to. Representative Heiberger.
I just like to make a slight correction. The original refers to groups covered by 501c of the federal. I believe you said 501c3.
Yeah, correct. Sorry. Rattled off my tongue. Any discussion on the amendment? Representative O'Howson. Oh, no, I thought I saw your hand move. No, Representative Carmichael.
Thank you, Mr. Chair. First, with your permission, a quick update on the play-by-play. It looks like Senate Bill 392 is on GO for tomorrow morning, and that is where the $50,000 quote-unquote sweep that was 2447 is showing up. And it looks like that the Insurance and Pensions Committee took care of that. So
thank you.
So we truly have a proverbial shell here. And also, there are no judiciary bills above
See that now.
tomorrow. Now, happy news aside, I'm not sure that this agreed upon amendment does very much to satisfy what are my concerns with this bill. I had a specific concern with this bill that Kansas Department of Revenue was not going to be able to access the information that they needed to determine certain types of exemptions, but that is specifically covered in this amendment. That's the good part of it. But this amendment makes it abundantly clear that this privacy law, if you will, applies not only to 501c3s, which are charities, but it applies to, as best I can tell, any nonprofit. Not only charitable nonprofits, but any nonprofit. It would cover, for example, 501c10s. My fraternity fits in that one. It will cover, most importantly, 501c4s. 501c4s are what you do if you want to form a dark money organization. The dues into the organization are unlimited in amount, and if you're a business, you can find a way to make it a tax-exempt contribution, and no one will ever know whether you gave any money, whether you belong to the organization, whether you gave 50,000 or 150,000, and then it's turned around into dark money for politics. If you think that's bad enough, think about the Knights of the Ku Klux Klan. There are a lot of nonprofit organizations out there that are really bad people. And if you want to facilitate them hiding their activities, then this is the bill for you. Now, some good friends of mine in this room that I've worked with for many years and gone through many battles with strongly believe that their 501c3s need to have some type of protection. I respect my friends, but I think they're being sold a bill of goods here that will have collateral effects and impacts far beyond the label at the top of this bill. an additional matter that comes to concern, at least concerns me. In Kansas, I can't walk up to you and say, you're a 501c3 or you're a nonprofit. You have to tell me who your members are. That's not the way it works. Private organizations are not subject to Kansas Open Records Act. Instead, the only way that I know of that you would find out who the members of a nonprofit organization are, other than the officers that might be disclosed in filings with the Secretary of State, would be in the context of a lawsuit, where you would go to the judge and you would say, Judge, I need to discover who the members of this organization are. Now, initially, you could do it by means of a record subpoena, and then they would respond with an objection saying, this is confidential information. You've got to show me why you need it. And that's the only way I can think of that you get to this information presently. We have provisions in our Code of Civil Procedure that deal with these types of privileged lists, if you will. And so a judge can be given the evidence to show that there is a good reason that the members of this organization's names do not need to be disclosed in a civil lawsuit. And the judge can enter protective orders concerning how the information might be used. The judge can send it to a special master to protect the privacy. There's a whole panoply of things already established in the law to take care of those circumstances. This amendment, however, is something different, because it now says, first, the burden is upon the party seeking those lists, which I wouldn't have too much trouble with, to come into court and prove a need for it. But then it applies a different standard of the law than what is used in other litigation. It has to be based upon, if I read the amendment correctly, clear and convincing evidence. Clear and convincing evidence, and I can't remember the magic language, but it's a standard of proof, or is it standard of evidence? I used to know it by memory. I see Representative Samples nodding. He's passed law school more recently than I am, but so maybe he can help me out of this quandary. But there's certainly no reason to put a clear and convincing evidence standard on this discovery, because we already have a tried and true method to protect this information from litigants who have no need of it. So, to try to close at least my position on this, as much as I like and respect many of the people who are bringing this bill to us, this amendment does not fix the things that are wrong with the bill, and I think arguably it may expand the bad effects of this bill to any nonprofit, no matter how devious, no matter how bad their purpose might be, and I don't think that's what we want to do. Thank you, Mr. Chair.
Further discussion on the amendment? Representative Sampson.
Thank you. I appreciate all the work that's been done and compromise and effort that's gone into it, but I've got to agree with the previous representative on subsection C3 there. That would apply in every civil case. That's getting into the province of the court. And to me, it's not letting judges do what they need to do to move litigation along. So both the compelling need and the clear and convincing evidence is a problematic area that I hope still gets some work before it sees final action. And then over on the second page, I've still got heartburn on subsection D1 that's not addressed yet. When it talks about each violation being not less than $7,500, I know plenty of good attorneys that if you turn over a list of 100 names pretty quickly, I think they're going to argue each one of those names was a violation and be asking for $7,500 for each names here, up to $750,000 or something like that, just as an example. So still got heartburn on that one. And then the third one there, I just D2, when it talks about the complainant can get attorney's fees, it's a heartburn I've always had, still do. I shared it last time, but hopefully if we continue to work this thing, it'd be a prevailing party status. So whoever the claims are brought against, if they end up prevailing, they'd be able to get reimbursed for their attorney's fees. So I do appreciate all the work that's been done on it so far, but I hope there's some more that can be done. Thank you, Mr. Chairman.
Further discussion? Not. I will close and move my amendment. All in favor say aye. Aye. All opposed say no. No. Ayes appear to have it. Ayes do have it. We would do that. Yes. Representative Carmichael votes no as a recorded vote. Now we're back on the bill as amended. Are there any further amendments? A motion concerning 2495. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2495 favorably as amended.
Is there a second? Representative Heiberger. Discussion? Oh. Okay, is there a second?
I saw him move.
So did I. Representative Humphreys with the second. Discussion, Representative O'Hopson.
Thank you, Mr. Chairman. I know this is my 6th year serving in the legislature, and my experience is that there's not been any perfect bill, but there's not been any perfect one. But I do also want to thank members of the NAACP, the Kansas Black Leadership Council, and everyone else who's actually have done work on this bill. As many of you know, members of the NAACP have had a history dealing with unfair harassment and persecution. I believe this bill provides nonprofit organizations with an additional layer of protection. And again, I appreciate everyone's work on it. Thank you, Mr. Chairman.
Representative Heiberger.
Thank you, Mr. Chair. And I certainly appreciate all the NAACP's work also, but I might save my comments. I mean, I was happy with the amendment because I think it corrected one thing I thought was wrong with it, but I still don't like the underlying bill. The way I read it, my perception is the really intent of this is to provide an additional layer of protection for donors to 501c4 organizations. And I can't support that. I think if you really want to help hide the names of the people who gave the money, who send those nasty postcards to you, you should vote for this. If you don't, you should probably vote against it. So despite the support for some groups I really appreciate, I'll be voting no.
Further discussion? Seeing none. Representative Hoheisel, you can close.
Close.
For the motion, all in favor say aye. All opposed say no. The ayes appear to have it. Ayes do have it. Motion carries. Those wanting their affirmative votes recorded, Representative Hoheisel. Those wanting their no votes recorded. Oh, and Representative O'Hopson. Those wanting their no votes recorded, Representative Carmichael, Heiberger. That is it. Now let's look at Senate Bill 367.
Mr. Chairman, Senate Bill 367 would require officers to file copies of receipts with the court when property is seized under a search warrant. And it also would provide requirements and procedures for the destruction or disposition of dangerous drugs and the return or disposition of weapons.
Any questions, committee? Are there any amendments?
It's not a, I'm sorry.
Question or comment or something from Representative Humphreys?
Thank you. How can we have another 367 bill? I mean,
I did not realize that until I was putting a list together the other night. I'm like, 367.
Yes.
Like, we should, some bills we should just never use the number.
Right, exactly. They
Right.
have an identity.
Yeah.
Retiring jerseys, right?
Right, right.
We'll just vote it down and that'll take it.
Okay, if there are no amendments, is there a motion concerning 367? Representative Hoheisel is just showing off because his wife is here today. Yes.
Something like that. I move we pass out SB 367 favorably.
Is there a second? Representative O'Hopson, discussion. Representative Carmichael.
Thank you, Mr. Chair. I intend to vote for this bill, but I do so with some reluctance. If you recall Mr. Klump's testimony, it does make good sense to set up a hierarchy, if you will, for the return of firearms to their rightful owner. However, we had testimony, as I think I mentioned during the discussion of this bill. I think it was here rather than corrections, but Sheriff Easter told us that one of the things he has problems with is seeing the same guns over and over again. And this bill, in my opinion, doesn't sufficiently do something about the guns that law enforcement keeps seeing over and over again. If it were up to me, we would broaden the circumstances under which a firearm is forfeited and, quite frankly, destroyed. And this comes from somebody who owns a lot of firearms. So don't get me wrong that I think people have a right to keep and bear arms and they're entitled to be proud of their firearms. At least I try to keep mine in good enough shape that I can be proud of them. But this bill doesn't go as far as I think some of us would like to see with respect to firearms used in violent felonies. Thank you.
Any further discussion? Representative Wheeler.
With regard to the previous comments, I certainly do respect its intention. And of course, I have ultimate respect for Sheriff Easter. But I would suggest, and I know it to be true, that if you destroy a firearm that you see over and over again, you will then see another firearm over and over again. So there are certain things that we can't cure. And this at least makes it more clear, and I support this bill.
Any further discussion? Representative Owen's hand.
Sorry, you're just kind of right in the way. So actually that conversation was in corrections. It's when we had our kind of state of the law enforcement address early on in the session, and Sheriff Easter shared that. And what Sheriff Easter's personal desire is that any gun used in a crime gets destroyed for the most part, and has actually been operating in violation of the law and doing just that. And so as a result, there is legislation through Fed and state right now that will close the loopholes that he is using, because the law is really clear as it comes to seized firearms, that unless used in a capital case, they cannot be destroyed. What this doesn't really address the destruction thereof. This simply addresses how it is to be returned. And if it is not returned, then it is to be disposed of as a indirect relation to the way that the law is written. And so the law is clear that firearms, whether when they are disposed of, are disposed or auctioned off, or whatever the process is, goes to federal firearms license holders, where they can then be resold compliant with federal and state law. So this bill doesn't specifically touch on that, but it does clarify in the event that it's seized and there's a not guilty situation or something like that. So I support the legislation. Thank you.
Any further discussion? Okay, Representative Hoheisel, you may close on 367.
Thank you, Mr. Chair. I close.
For the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. The affirmative votes wanting to be recorded: Hoheisel, Neely, O'Havison, Carmichael, and Heiberger. Now let's look at Senate Bill 395.
Mr. Chairman, Senate Bill 395 would protect private property from unauthorized access by certain government officials and unauthorized video surveillance.
Any questions for Natalie? Representative Carmichael.
Thank you, Mr. Chairman. Ms. Scott, could you refresh my recollection, because I think that the bill has been amended somewhere along the process to perhaps limit its applicability only to video cameras that Wildlife and Parks might place on private property without consent of the owner. But I know the original bill was broader. I just can't remember what, if anything, had happened to that. Can you help me with that?
Sure. Mr. Chairman, Representative Carmichael, I believe the changes that you're talking about are to the definition of surveillance. So as originally introduced, surveillance would include physical presence on the property. But the way that the Senate amended the bill, surveillance now would just mean the installation and use of electronic equipment or devices on private property, including but not limited to the installation and use of tracking devices, video camera, or audio recording devices. So that physical presence part was removed.
And as I recall, the bill only applies to Wildlife and Parks employees or enforcement officers, not others.
Mr. Chairman, Representative Carmichael, that is correct. The lead in at line 6 simply just applies it to no employee of the Kansas Department of Wildlife and Parks.
Thank you.
Any other questions for Natalie? Representative Owens.
Thank you, Mr. Chairman. Could we dig into that just a little bit more? So am I understanding correctly that we are excluding physical presence, which means that indeed their physical presence on my private property no longer needs a warrant? Or am I misconstruing that?
Mr. Chairman, Representative Owens. So what the bill does is say that no employees of the Department of Wildlife and Parks can conduct surveillance on private property. But then surveillance is defined as just that use of electronic recording equipment. So as originally introduced, the bill would have prohibited physical surveillance, meaning that an employee of Wildlife and Parks would not be able to physically be on your property. So that was removed. And so now that prohibition is only on electronic recording devices.
So they can be present physically and surveil my property.
Under certain circumstances. So the Fourth Amendment to the U.S. Constitution puts some parameters on searches and seizures. And so if they were to have a warrant, that, no question, they would be able to go on your property then. But there are certain circumstances, particularly when it comes to the outside the curtilage closest to your home, where law enforcement can physically be on your property without a warrant. We call that the open fields doctrine. And so this, since we're taking the physical presence part out of it, the physical part would not be prohibited anymore than it is currently under Fourth Amendment doctrine. So that analysis would be done on a case-by-case basis in the court. But what would happen here is that even though perhaps the Fourth Amendment would allow some of this video surveillance, you would be further restricting what would be allowed under the Fourth Amendment.
Thank you.
Representative Hobson.
Oh, sorry. He was first. Thank you, Mr. Chairman. Question for you. So just to follow up on Representative Owens. So if someone is actually not on the property and say, for instance, they are maybe on a property opposite and they have like a drone that goes up since they're not on the property, but there's surveillance, is that, does this law we're talking about today, does that prohibit that, or is that what can you help me out there?
Sure. Mr. Chairman, Representative O'Hobson. So I think that if you were to fly a drone over property, then you would be using an electronic recording device on that property.
Does this law prohibit that, or is that still kind of like within the boundaries? That's what I'm trying to understand.
Well, all I can really tell you, I guess, is exactly what the words would be. So it would prohibit then the installation and use of electronic equipment or devices on private property, including the installation and use of a tracking device, video camera, or audio recording device to monitor activity or collect information. So if an employee of the Department of Wildlife and Parks operating a drone over your private property counts as installing and using electronic equipment, then that would be prohibited. I can't say what how a court exactly would interpret that. So, yeah.
Thank you. Thank you.
Representative Heiberger.
I was going to comment if we're done with questions.
Okay, so let's, I'll put you first on the list. Any amendments? Representative Owens.
I'm going to go with maybe because I want to continue to dig into this physical presence thing. Maybe I'm the only one not fully understanding why it was here to begin with and what we accomplished by removing it. Because it seems like to me that we would want that here if we're trying to truly protect our Fourth Amendment rights here. So I will welcome the conversation, and if possible, the chairman reserve the right to enter that amendment in a second.
So I guess my initial response would be that we're not limiting or expanding or changing your Fourth Amendment rights. That they're there no matter what this bill says. Well, I guess. Okay, yeah, I get Natalie's giving me that look. Okay,
See?
so you'll still have your Fourth Amendment right. Correct. No matter what we put in this, we're not going to impact your Fourth Amendment right, is what I was attempting to say. But Natalie can say it better.
Thanks, Mr. I'm not sure I can really say it better. So what you're doing here is, so if this is the amount that law enforcement can do under the Fourth Amendment right now, you're making that a little bit smaller, because there would be some instances right now where electronic equipment could be installed and used. Now, you did hear in testimony that currently the Department of Wildlife and Parks by policy has prohibited that from happening anyway. But so if you were to put the physical part back in, you would be even further restricting that down. So it does alter it. It does, but it doesn't, obviously we can't restrict a Fourth Amendment right anymore. But yeah.
Some of the discussion we heard was the I think maybe from Representative Carmichael, his fishing pond in the middle of a field somewhere. And so Wildlife and Parks wanted to walk up and confirm whether or not he had a fishing license, or there was someone hunting in a 180 acre pasture somewhere, and they wanted to make sure you had a hunting license. Those types of things they'd still be able to do. Yeah, absent landowners, those types of things. Right, it does not, but had the language not been changed by the Senate, it would have changed that. Wildlife and Parks would not have been able to go on and confirm you had the fishing license or the hunting license.
If I may, don't we already have a procedure that allows that to happen with the purple poles? If I paint the poles purple on my land, I'm in essence giving my permission for that to occur, for their physical presence to go on my property to check that. Purple poles are purple poles. That's what I thought. Purple pole. I paint my poles purple. That allows KDWP, that allows them, if they see something out of whack on my property or somebody, I'm giving them my consent by painting my pole purple, that they get to go on my land and check that. Without that, I am not giving them my consent to go on my land. Am I missing the purple pole doctrine?
I don't know. I've seen purple poles, but I had no.
Natalie, what do you know about purple poles?
I think I missed that course in law school. A little out of my wheelhouse, but I could certainly get with our kind of agriculture folks, are the ones who normally deal with kind of wildlife and parks issues, and see if they can get us.
I just want to be clear. I'm not the only one that occasionally sees purple poles. Oh, okay. All right. Just making sure, because I thought I knew what they meant, and glad I'm not seeing things. That would be great. Yeah. Thank you.
Over here we have Representative Wheeler.
Thank you, Mr. Chair. It's been too long since I took property class, but when you own property, you own the land, and then do you own all above it? There are
Natalie?
lawsuits of interference with light and air, but that's off your property. And I'm talking about this because this drone that flies
Drone
over,
question.
quite frankly, I'm concerned that we are dealing with a non-existing problem by creating very complicated legislation. And if a officer, whoever, through a warrant or exigent circumstances, is able to spot a pot grow in the grove of trees, I'm all in favor of it if it's lawfully done. But right now, I think what we're doing here, for what we heard from Fish and Game, they're not doing anyway. We're just botching this thing up badly. I just want to make that comment. Thank you, sir.
Representative Long.
Thank you, Mr. Chairman. So Natalie, I know this bill expressly defines surveillance. And I know this bill is laser focused towards wildlife and parks. So my question is, let's go away from wildlife and parks and go to regular law enforcement, sheriff, KBI, whatever. Can they come on and use these same surveillance items?
Mr. Chairman, Representative Long. So law enforcement officers who are not employed by Wildlife and Parks would be able to do whatever is allowed under the Fourth Amendment. So this restriction would only be on employees of Wildlife and Parks. So I don't want to say that law enforcement officers can go on your property and install these devices, because they only can to the extent that the Fourth Amendment would allow them to do that without a search warrant.
Okay, and to follow up, Wildlife and Parks can also do it with a search warrant or that mechanism, right?
Yes, let me find. So starting at line 14, and you'll see, I guess it's really, you want to start at line 10, unless, or 9 even, unless authorized pursuant to a lawfully issued warrant, court order, or subpoena, or under one of those exceptions to the search warrant requirement, exigent circumstances, consent searches, or the plain view doctrine, which are all kind of aspects of Fourth Amendment case law.
Well, if you were to consider that Wildlife and Parks may work in conjunction with law enforcement at times, then this bill doesn't accomplish a lot if law enforcement can do it and Wildlife and Parks can't. So thank you, Mr. Chairman.
Yeah, you're welcome. Okay, I think I found the purple post, and it's different than what you thought. It's. You want to explain what you found, Representative Owens?
Yeah, that we learned a little bit about Purple Post. It's not just a sign you support K-State. It is actually replacing the by written permission only, hunting and fishing by written permission.
Hunting and fishing, yeah.
My misunderstanding that had something to do with KDWP, and I apologize for that misunderstanding. But we do have purple pole painting.
I see that. Representative Carmichael.
Oh, for
I think Representative Keither has something on her mind.
She does.
I was going to help Representative Owens out with the purple pole because I certainly knew about the purple pole. But I do want to make a similar comment about this bill, agreeing with the representative from Garden City. I think this is something that we are just digging a very big hole and making a bigger mess out of it. And I think we ought to just let it go. That's my opinion. Thank you, Mr. Chair.
Representative Carmichael.
Thank you. Gosh, we've been around. This is what Judiciary ought to be doing. I mean, you know, a lot of us would describe this as a first year property law discussion, but it's good for some of us to have those discussions every now and then. The Purple Post law, historically, Purple Post meant no trespassing, and it arose out of a circumstance where not all citizens were literate. And so in certain states, either by common law or statutorily, painting your post purple was the equivalent of posting your land as no trespassing. However, if I am reading some stuff from the Wichita Eagle, and maybe the chairman has it at hand, we passed a purple post law that said it's no trespassing, but also if you're on that land, you have to have written permission of the landowner if you're going to hunt. And if you don't, then you're hunting without permission, you're trespassing. And I think that also obviously inferred that the law enforcement officer, the wildlife and parks officer under the so-called open fields doctrine, had a right to go on to that property to find out whether or not you possessed a hunting license or a fishing license, whatever it may be. So that's my best recitation. I used to have a place in Southwest Missouri. If you live in Southwest Missouri, you know what purple post means. If you go across that purple post, somebody's liable to shoot you, so you don't do it. Now, let's talk a little bit, though, about the open fields doctrine and the concept of overhead surveillance and surveillance from other property. General rule is when law enforcement is where it has a legal right to be, it's entitled to look and see anything that goes on. Law enforcement can stand can stand on the street in front of my house and can see what's going on in my backyard. And if I'm back there smoking marijuana, they can come right on in and they can arrest me and take my marijuana because they observed it from a place they were lawfully entitled to be. Now, if on the other hand, they break into the fence around my curtilage and they hide back there behind the garage and catch me smoking marijuana in my backyard, then there may be a question as to whether or not they were legally entitled to be there, and therefore their observations or the evidence that they gained when they were not where they were entitled to be without a warrant may well be excluded from evidence under the fruits of the poisonous tree doctrine, something like that we had in Crim Pro a long time ago. So a lot of these questions we've been talking about, so long as wildlife and parks is on arguably even somebody else's land, and can see what's going on, then they're entitled to come in and enforce the law. Drones. The law on drones is not exactly certain, but it is analogous in some ways to the law of fixed-wing aircraft and helicopters used by law enforcement for surveillance purposes, in a poorly worded decision, and I think this is Sandra Day O'Connor, but I'm not positive of this. She basically said, even though you own from the center of the earth, as Professor Griggs told us, from the center of the earth to all the way to the moon, all the way into the skies, law enforcement couldn't violate the FAA regulations and fly lower than what would be allowed for an aircraft, because if they did, then they're in violation of the law. They're not entitled to be there, and that which they see cannot be used against you, so to speak. I'm not sure about what the law is on drones. I suspect it might be similar, but I don't know. Final thing is this concept of the open fields doctrine. The case in Kansas is State v. Swinney. It's a 2006 decision. It is, to my reading, entirely consistent with what the federal law what the United States Supreme Court decisions have been for as long as known to most lawyers. And that is that whether it's right or wrong, we don't have the same expectation of privacy in an open field that we own that we do in the curtilage or the area around our home. And so since the court thinks we don't have that expectation of privacy, that generally means that under the open fields doctrine, no expectation of privacy, law enforcement is entitled to do what law enforcement does. The problem with that decision, in my opinion, though, becomes when it's posted no trespassing and law enforcement is now where they have no right to be. That's a more difficult question. Now, having gone down all these things, I agree with my learned friend from Finney County. Thank you.
Representative Schreiber.
Trying to figure out what curtilage means, but yeah. I do have that. So as I recall, this probably an open question, and I don't know if Mr. Klump, I know, could probably answer it, but conservation officers they do go through KLETC, enforcement officers, yes. Okay, that's correct then, Mr. Cordledge. Mr. Carmichael, I'm sorry.
The enforcement officers see, but not all.
Okay, thank you.
Okay, Representative Wheeler.
Thank you, Mr. Chair. I'm going to be quick about this. I would like to know how many hours of continuing legal education we can get from this hearing.
Supreme Court rule gives us, I believe, 6 hours a year. All you have to do is
signed off on that form. I'm asking for additional hours.
Representative Heiberger.
Are we through with questions for the revisor?
If you have one, go ahead and ask.
No, I think.
Oh, okay. No, actually, we were on. Do we have an amendment? That's where we're stuck. But Representative Samsel. Yeah, right.
Thank you. I just didn't know. Is the Department of Wildlife and Parks still opposed to this in any way, or did these amendments alleviate their objections? It seemed to be the physical presence piece I thought was the example he used for their biggest objection, but I didn't know if they worked on these amendments to get it where it is.
So I'm not pulling it up. I'm pretty sure they were a neutral before us, and I think I think they were opponents when it was in the Senate before they removed that language. So now they're neutral after the amendments were made in the Senate.
Okay, I saw it was dated February 1st, so that's helpful. Thank you.
Representative Heiberger.
What amendment are we working on?
We're not. The amendment that the Senate had that removed the language that Representative Owens is contemplating putting back in. So let's go back to that. Do we have any amendments?
No, Representative Owens does not feel confident enough in his legal education to be offering said amendment at this time, but may reserve the right for a later time. Thank you.
Okay. So does anyone else have an amendment? If not, is there any motion concerning Senate Bill 395? Representative Hoheisel.
Mr. Chair, I move we pass out SB 395 favorably.
Or second, Representative Neely. Further discussion now on the bill itself. Representative Heiberger.
Well, I've been dropped off a couple of times, I think. So it's all been mostly said by now, but I think this bill really doesn't do much. And to the extent it does, I'm not sure it's a real issue here in the state. We've seen it before. It was filed in response to a court case in Tennessee. There's no evidence of any problem here. I joined with my other colleagues who asked questions to the advisor earlier and won't support it.
Any further discussion?
Yes.
Representative Keither.
Thank you, Mr. Chairman. Oh boy, it's hard to get noticed in this little hand here. Would you allow a substitute motion to table the bill?
Yes, I would.
Then I've made so moved.
We have a motion by Representative Keither to table, a second by Representative Wheeler. Discussion on the motion to. Oh yeah.
No.
Okay, no discussion.
Mm-mm.
Yeah, we don't need to discuss anything. Okay, you've heard the motion. All in favor say aye.
Aye.
All opposed say no. The ayes appear to have it. The ayes do have it. Let's look at Senate Bill 434.
Mr. Chairman, Senate Bill 434 would create exemptions in the Open Records Act for records that contain captured license plate data or that pertain to the location of an automated license plate recognition system.
Any questions for Natalie? Even hesitant to ask that. I see your hand. Oh, you're taking. Is it back up? There we go.
I do.
Representative Keither.
Thank you. Natalie, could this have any impact on the school bus bill? License tags?
Mr. Chairman, Representative Keither, I don't think that this would have, so what the school bus bill does is allow for the contracting to install cameras on bus information. And so there's nothing in there that would then allow someone's license plate information to become public if they violate that. So their license plate information is used by what now will be the Kansas Highway Patrol to issue the civil penalty. But that shouldn't be implicated in any way with this legislation.
Okay. It just occurred to me and I just thought I'd ask the question. Thank you.
Any further questions for Natalie? Are there any amendments on Senate Bill 434? Or a motion concerning Senate Bill 434? Representative Hoheisel.
Mr. Chair, I move we pass out HB 434 favorably.
Is there a second? Representative Schreiber. Forgetting everyone's names. Discussion. Representative Carmichael.
Thank you, Mr. Chair. 2 points I'd like to make here. First, I might respectfully disagree with our revisor because both the school bus bill and this bill deal with recording images of, among other things, license plates. And they both, I think, deal with limitation on access to that information through Cora. An argument might be made that would therefore be germane to use this bill as an attempt on the floor to add a school bus bill. Now, I'm not the expert on germaneness. My good friend, my good friend Blaine Finch is the expert, as is our chairman. But I think you could make an argument that there are 2 points of contact and maybe you could use this as a vehicle to amend in that. So I just put that out there, and I see the reviser may be better prepared. If I could defer.
Mr. Chairman, Representative Carmichael, I just wanted to make clear that my explanation was in no way trying to say whether something would or would not be germane or single subject to an amendment on the floor. I simply was saying that nothing in the law there conflicts with the access to someone's license plate information.
And Mr. Chairman, I apologize for having inadvertently made that inference. And I think I understood what the reviser was saying, but I wanted to make sure people also understood that perhaps it could be a quote vehicle. The second, though, and more important point I want to make with my friends here is this bill doesn't go far enough, in my opinion. I believe that we ought to have a limitation on how long law enforcement can retain these records. I don't think, and you may recall that Lieutenant Slaughter from the Wichita Police Department said that they keep it for about 30 days because that's the nature of their contract. And I don't have any problem with that. Others suggest perhaps 6 months. And of course, if we were looking for BTK, we might want to have it retained for 20 years too. So we're not ready, I don't think, today to impose that type of limitation. Otherwise, I would have drafted an amendment to limit this to about 6 months. But I think that's a topic the legislature needs to look at, and it's one that we need to do by way of hearings so that various concerned parties can explain their thoughts rather than somebody like me trying to pop an amendment and say, well, he said 30 days, so, fine, let's do it. But we need the bill too, because as it stands right now, these license tag data information, I think, is arguably subject to CORA. The converse argument is, well, they're investigatory records, but they're not necessarily being used to investigate any particular crime or activity. It just might be my wife's divorce lawyer wants to know where I was on a given evening. And by the way, she has Google tracking. She knows where I am. She told me where I was last night. So, but the point of it is we ought to look at limiting that. And I think we also ought to be looking at limiting access to these records in connection with civil litigation. Under this statute, I don't think we're doing that, if I recall correctly. And so in that sheaf of initial discovery that lawyers send out, a record subpoena to the local police department for all the dates, times, and locations they have of somebody's license plate may become the norm, and I think we'll want to stop that. Now, all that being said, I'm going to vote aye, but it's not the bill I would really have liked to have seen.
Further discussion? Not seeing any. Let me check Representative Keither's hand. It's not up. Representative Hoheisel, you may close. You've heard the motion. All in favor say aye. Aye. All opposed say no. Motion carries. Affirmative votes wanting to be recorded: Hoheisel, Ohabisam, Carmichael, and Heiberger. We have two more committee. Senate Bill 435.
Thank you, Mr. Chairman. Senate Bill 435 would expand law enforcement officers' jurisdiction to include situations when an illegal act is observed that the officer reasonably believes will jeopardize the safety of any person without immediate action.
Any questions for Natalie? Or any amendments? Motion concerning 435, Representative Hoheisel. Second by Representative Neely. Discussion? None. Representative Hoheisel, you can close.
I close.
Heard the motion. All in favor say aye. Aye. All opposed say no. Motion carries. Affirmative votes: Hoheisel, Ohabisam, Carmichael, and Heiberger. Neely as well. He can't make up his mind if he wants to be recorded or not.
All in, you're all out, buddy.
Okay, 483.
Mr. Chairman, Senate Bill 483 would increase the criminal penalties for theft and criminal damage to property involving remote service units, such as automated cash dispensing machines and automated teller machines.
Any questions for Natalie? Any amendments? Or a motion? Representative Hoheisel.
Thanks, Chair. I move we pass out SB 483 favorably.
Second by Representative Hobson. Discussion? None. Representative Hoheisel, you may close.
Close.
Heard the motion. All in favor say aye. All opposed say no. Motion carries. The yes votes wanting to be recorded. Hoheisel, Hobson, Carmichael, and Heiberger. That's it for today, committee. Tomorrow, I'm about to make the same announcement you want me to make, I think, Representative Ralph. Tomorrow, we have, continuing on the list is House Bill 2697. That is the bill from KDADS dealing with competency evaluations. They're working really hard at coming up with something, and I really want to try to get that bill out of committee. If we're not there, I've already inquired about the possibility. If they're not there by tomorrow, they're not going to be there likely this week, and so maybe we would meet early next week, get permission from leadership to meet after the deadline. So we'll see where that's at. Probably later tonight we'll make that decision. And then the two bills we heard today, Senate Bill 419 and House Bill 2736. And I believe that's everything, but in the event I forgot something, any other bill we've previously heard. Representative Ralph, I'm guessing, is going to say if anyone wants to carry any specific bill, let him know, because he's going to be assigning those here shortly. And if you want to pick a bill or two, let him know. If not, he'll pick a bill or two for you. That's all we've got. We will see you all here tomorrow. Thank you.